Covenants not to compete can a lot of times be one of the most contentious terms negotiated as part of a purchase agreement. The buyer wants protection from the seller that the seller is not going to just open up a new business and operate it competing with the purchaser. On the other hand, that seller needs to be able to and wants to be able to continue to earn money and have a livelihood. So they a lot of times want to either not have the covenant not to compete in the purchase agreement, or else limit it to a very short period of time. We commonly include covenants not to compete in fairly specialized types of businesses. For example, we had a client who operated a business out of North Dakota where connections were very important to the success of that business. And the buyer in that case demanded a 2-year covenant not to compete, and our client was willing to agree to it because he had a significant premium on his sale price. Another important aspect of covenants not to compete is the statutes in South Dakota, and the case law are very specific about what can be in covenants not to compete, such as the time and the geographic scope of that particular covenant not to compete. So it's of utmost importance to make sure your covenant complies with the laws in South Dakota to make sure you don't lose that protection if you are a buyer. The allocation of cost is another important aspect of the purchase agreement that can be negotiated. It's very important to have it negotiated up front so there isn't a dispute at the last minute over who has to pay a particular cost. I always try to address all the particular costs in the purchase agreements that I draft so that we don't have any risk, or so we lower our risk that closing will not be complete due to a small hang-up with a closing cost. And the approach that I take with all of the closing costs is that they're up for negotiation. There are a number of closing costs that can be negotiated. For example, with a real estate purchase, there's the title insurance costs, there's transfer fees and recording fees and taxes that need to be prorated and rent payments. All of these different particular closing costs can be negotiated and sometimes can have a very significant effect on the overall amount of money that goes to the seller or the amount of money that must be paid by the purchaser. The approach that I take when negotiating a sale or purchase with my client is that we need to get all of their trusted advisors involved in the process. Of course, the lawyer is there to protect the client from a legal standpoint, whether to minimize risk or increase the purchase price through negotiations for our client. However, it's also important to get other trusted advisors involved, such as the client's accountant. The accountant can provide significant advice as far as the allocation of that particular purchase price to minimize the taxes in the future that must be paid. We also will sometimes involve insurance agents who are familiar with the particular liability insurance that's associated with that company. We need to involve these agents to make sure our clients are covered under the policies that exist for the risks that they might encounter. Okay. One of the most important things before purchasing a business that a client needs to do is to perform the proper due diligence. This is important to make sure the client is in fact purchasing the business that they bargained for. We commonly assist our clients in performing this due diligence to ensure that their interests are protected and that they are purchasing the business that they wanted. For example, we commonly look at contracts that exist with the business that they're purchasing to make sure there aren't onerous terms in those contracts and to make sure that those contracts will continue for the proper period of time for the business that they're purchasing. We'll also help assist in reviewing financial statements and tax returns to make sure that the business is operating in a profitable manner, and to make sure that there aren't expenses that are being accounted for in an improper way or an inaccurate way to make that business look more profitable.